If you've ever looked into estate planning, you've probably heard the terms revocable trust and irrevocable trust. They sound similar, but the difference between them can have a major impact on two things clients care deeply about: taxes and control. Hi, I'm Jim Fletcher, Georgia estate planning attorney. Today I want to talk through how each trust works, what you're really giving up or keeping, and how those choices can play out in real life. Let's start with a revocable trust. This is the type of trust most people encounter first. A revocable trust is flexible. You create it, you typically serve as your own trustee, managing your own assets, and you can change it, amend it, or cancel it entirely at any time during your lifetime, as long as you're mentally competent. Think of it this way. If you put your house, bank accounts, or investments into a revocable trust, you still treat them like they're yours. It's basically transparent. You can sell the house, move money around, change beneficiaries, or decide later that the trust no longer makes sense. From a control standpoint, you are still very much in the driver's seat. Now let's talk about taxes. Because you retain that level of control, the IRS essentially ignores the revocable trust for tax purposes. The assets in the trust are still considered yours, they're part of your taxable estate, and any income the trust generates just shows up on your personal tax return. Here's a simple hypothetical. Imagine Sarah creates a revocable trust, she transfers her $1.5 million estate into it, and then when she passes away, that trust helps her family avoid probate court, stress, delay, and that's great. But from an estate tax perspective, nothing has changed. The full value of those assets is still counted as part of her estate. The trust did not reduce estate taxes or shield assets from creditors during her lifetime. That leads us to irrevocable trusts, which are very different animals. An irrevocable trust, as the name suggests, is not easily changed once it's created and funded. When you place assets into an irrevocable trust, you are generally giving up legal ownership and a significant degree of control. Someone else is usually the trustee. You can't simply decide later to pull assets back out because you changed your mind. That loss of control is exactly why irrevocable trust can offer powerful tax benefits as well as asset protection benefits. Because you no longer legally own the assets, even if you're the beneficiary, they are often removed from your taxable estate. Depending on how the trust is structured, future growth on those assets may also escape your estate's taxation. In certain cases, irrevocable trust can provide income tax benefits, creditor protection, and even protection from Medicaid nursing home eligibility spend-down rules. Here's another hypothetical. John owns a growing investment portfolio worth about $3 million. He expects it to double over time. So he creates an irrevocable trust and he puts those investments into it. He no longer controls the assets directly, but the trust is set up for the benefit of his children. When John passes away, the assets and all that growth are outside of his estate. That might mean significant estate tax savings compared to holding everything outright or in just a revocable trust. But there's a trade-off, and this is where many people hesitate. With the irrevocable trust, you can't easily change course. If your financial situation changes, or tax laws change, or family relationships change, your flexibility is limited. A trust protector can lessen this risk, but that's why irrevocable trusts require careful planning and a clear understanding of your long-term goals before you sign anything. Control is often the deciding factor. With a revocable trust, you maintain control and convenience, but you don't get the tax reduction or asset protection benefits during your lifetime. With an irrevocable trust, you potentially reduce estate taxes and you do protect assets. You give up technical control in exchange. Another way to think about it is timing. Revocable trusts shine as an estate administration tool. They help things run smoothly after death, avoid probate court, maintain privacy. Irrevocable trusts are more about proactive planning during life, especially tax minimization, asset protection, or legacy planning. Well, it's not always an either-or decision. Many estate plans use both. A client might have a revocable trust as the foundation of their estate plan and layer in one or more irrevocable trusts for specific purposes like asset protection, life insurance planning, gifting strategies, or long-term care planning. The key takeaway is this: trusts are tools. There's no one-size-fits-all solution. The right choice depends on how much control you want to keep, how concerned you are about taxes, and what you want your assets to accomplish over time. If you're considering a trust, the most important step is understanding the consequences before you move assets. Once assets go into an irrevocable trust, there's usually no easy undo button. On the other hand, relying only on revocable trust planning alone may mean missing opportunities to reduce taxes or protect wealth. A thoughtful estate plan balances control, flexibility, and tax efficiency in a way that fits your life, not just today, but years down the road. Need help with your estate plan? Give me a call. I'll make it simple.